So there is some case law where judges have said, all right, look, you don't have to have an annual meeting, but you have to have some acknowledgement of recognition that that you're treating the LLC as a corporation. Absent that, you're at risk. Now, those cases, they have not, it's dicta in those cases. There's no case law that says, oh, now it's binding precedent that all LLCs must have an annual members meeting. That's not a thing. But my suggestion is to clients is, look, have a meeting once a year and put a unanimous written consent in lieu of an actual meeting, or put a unanimous written consent in lieu of an actual meeting in your minute book. It's an hour, hour and a half of paralegal time once a year, costs you a few $100s, and it keeps you buttoned up, as I like to say. Any questions about that? Okay, guys, that's about all I have. So, how are we doing on time?
12:46.
Perfect. No Q. I allowed 15 minutes exactly for Q&A.
Can you treat a corporation like a tenancy by the entirety between spouses?
Jake asked if we could treat a corporation like as a tenancy by the entirety between spouses. I'm not sure exactly what you mean by that. Are you saying can a husband and wife own a corporation together? The answer is yes. Oh, I'm so glad you asked that question. That was like a softball for me. Thank you. So, the answer is yes, you can. I don't know, it's tenancy by the entireties, meaning what? Upon death?
Mm-hmm. So let's say the husband's the only, member of this LLC, and you pierce the corporate veil against the husband. Wouldn't that only allow you to get a judgment against the husband's assets rather than the marital assets?
Well, that's an excellent question. Thank you for asking it. The answer is this. If a husband and wife come into your office and say, we want to form a business, whether it's a sub-S or an LLC is irrelevant, but we want to go into business together, I always recommend that they don't both own it. And the reason is this. Pennsylvania is one of 7 states in the entire country that says marital assets can't be used to satisfy an individual debt. What does that mean? That means if I drive out of here tonight and on my way home I tattoo a school bus and kill a bunch of kids, and our insurance isn't sufficient to satisfy the debt that the personal injury lawyer is going to bestow upon me as an individual, they will not be able to, that personal injury lawyer will not be able to get to the assets that Susan and I own jointly. Now, that's the rule in Pennsylvania. That's not the rule in every jurisdiction. So you have to check where your client is located. And that's really important because I get husbands and wives that want to own the company together, and I say, no. Only one of you gets to own the company. The other one can work there. The other one can be an officer. The other one can be a president, secretary, and treasurer. But you both can't own it, because if you both own it, and a creditor pierces the corporate veil, then they're able to get to, if they're successful in piercing the corporate veil, they're able to get to the assets of the owners. Well, who are the owners? Husband and wife. Well, what do the husband and wife own? Marital assets. So all marital assets come into play when the husband and wife both own stock in the company or interest in the company. Laura, do you have a question? We lost Lauren.
No, I was agreeing. I was nodding.
Oh, okay.
I understand.
There's a hand that's raised.
It's the mouse.
That's right. Thank you. All right, so do you guys get that? It's really an important thing to remember to tell your husband and wife clients, so that if there's only one of the two that owns the business, and the creditor is successful in piercing the corporate veil, then they can't get to any marital assets. So you tell your clients, your married clients, own everything together, right? Own everything together, not separate, and only one of you gets to be the owner of the company that you formed together as a spouse, or with your spouse. Does that answer your question?
Kind of. I was a bit rude.
Ask, clarify.
Well, is there a way that you could get to marital assets with just a single member?
No. With a single member LLC? No, because the debt is the individual's debt, and they can get this ring, right? They can get this jacket, but they're not going to get marital assets. What are marital assets? Anything that we own jointly. House, bank accounts, cars. Okay? What's up, Mish?
Can you explain then why there's a benefit of family limited partnership?
Why we use a family limited partnership?
Yeah.
Yeah, so family limited partnerships are not as popular as they used to be. Prior to LLCs, we used family limited partnerships a lot, but now that we have LLCs, we just skip that step. You guys know what a limited partnership is? A limited partnership is where you have a limited partnership is where you have, so this is the structure of an LP. You've got a general partner, and a limited partnership can't act except through its general partner. And then you have a bunch of limiteds. Or you don't have to have a bunch, you have one or more. And so what happens is, usually the general partner is about 1%, and your LPs own the rest. But your limited partners are exactly that. They're limited from liability. The general partner holds all the liability. And so what we do is, and this will be a mistake, you'll see this sometimes, unsophisticated business owners will make themselves as an individual the general partner. They might get this right, but they'll make themselves the general partner as an individual, and that puts their individual assets at risk. So what we do is we form a corporation or an LLC to be the 1% general partner. And so now you've got an LLC that gets the benefit of the corporate veil that only owns a very small amount of the business, holding all the liability. Now, if you think about it, why go through all that if we can just have an LLC with members who are protected as long as you engage in corporate governance? So we kind of skip this step and just use an LLC. Sometimes I can't think of a good example for you, Mish, of why you would use a limited partnership instead of an LLC. It's very rare.
I think the example I was thinking of was somebody who owns multiple businesses, like they had a construction company as well as a bunch of different businesses. They wanted to have an umbrella to have all the businesses in that business.
Yep, and so here's what we recommend for that. We have the Michelle Ross Holding Company, Holding Co., and I'm going to tell you to be an LLC. And under here, we're going to have LLC number 1, LLC number 2, LLC number 3, etc., etc., etc. You get it? Now, does that answer your question?
Yeah, it does. So I'm trying to think of, because we're going to eventually either have a lawsuit against or refer out
can layer it however you want. You can, and you know, under this LLC can own another LLC.
So if you can pierce one, it doesn't necessarily mean you can pierce all of them?
No, you get the benefit of the corporate veil every step of the way.
Okay.
Now, if you really want to get fancy, what I do is, and you have to have a client with enough money and sophistication and an active business to do this. But we also we form a management company, right? I've got Holdco, and then over here I form a management company. And the management company is the company that houses all of the back office resources for these companies. Because if you guys think about it, remember, a widget is a widget is a widget. HR function can be the same, marketing, sales, accounting, all what I call back office management or administration. That could be the same when you have common ownership. And so what happens is we have the management company perform services here in exchange for dollars here, right? Services, pay for services, pay for services, pay for services. And then so all your money here gets bubbled up to the holding company and gets distributed to your owners. And the other thing that's slick about this is you don't have to have the same ownership, right? There can be, well, strike that. That's not a good example. But when you do your say for example, I formed another one over here, and this was owned 50% by the Michelle Ross Holding Company LLC, and then the other 50 was owned by somebody else. That's okay. I do this with real estate a lot, right? Your client, you never want the same entity to own multiple units of real estate, because that means that any one single unit puts the rest of them at risk. Right? Because remember the example, when you have an LLC or a corporation, all of the risk is within the corporation itself, absent piercing the corporate veil. So if I have one LLC and I have unit 1, unit 2, unit 3, and one of those units, and this happens, right? I got a call on Christmas Eve about 8 years ago at 10:30 at night, and the client said, Dan, he said, you're never going to believe this, I need your help. Somebody was just murdered in one of my apartments. I'm like, holy crap. So it happens, right? But then one unit or one piece of real estate or one house or apartment or whatever you want to call it puts all the others at risk. So this is a bad idea. Really what you want to do is you want to own each unit similar to the corporate structure that I showed you before, or so you can have a holding company, or you just have all individual LLCs. Oops, 2, 3. All these different LLCs owning the different units. Now, if you want, you can put a holdco up top, oops, to own these different units. And then you can do, again, shared services, right? You don't have to have a management company. You can have all of your managed services up here and perform services for each company in exchange for dollars coming back the other way. Does that make sense? All right. Any questions? If you guys have any questions after we conclude, feel free to stop by, give me a call, send me an email, whatever you want to do. But now I'm guessing we're really close to the end.
1 o'clock.
1 o'clock on the dot. Bam. Love it. All right. Hey, you guys. Thanks. Have a good weekend.
Good meeting.